Yeah. All righty. Good evening, everyone. It is Monday Night Politics, brought to you by the Dallas Examiner and Molly Belton family. So thank you all for coming out this evening. We're going to get started with discussions from judicial race candidates. But first, I would like to thank our sponsors for helping making this evening possible. We have the NAACP Dallas chapter, Dallas Alumni Chapter of Delta Sigma Theta Sorority Incorporated, Metropolitan Dallas Chapter of Delta Sigma Theta Sorority Incorporated, Alpha Sigma Lambda Chapter of Alpha Phi Alpha Fraternity, and the Dallas Alumni Chapter of Kappa Alpha Psi Incorporated. So we are going to start with the Justice Supreme Court Place 7 race first. And we're going to have our Judge Staci Williams give her 2-minute introduction, and then we will open up the floor for questions to the audience. All right.
Good evening. It's a pleasure to be back. And can everyone hear me? It's a pleasure to be back in Dallas. My name is Staci Williams. I'm your judge of the Dallas 101st District Court. You've elected me twice, and I appreciate and thank you for your vote. I will be here, but I'm running for the Texas Supreme Court. And I think that the Dallas Morning News 3 weeks ago got it right when they said experience matters, and the Dallas Morning News endorsed my candidacy over my opponent. Besides 27 years of legal experience and being a 2-term district court judge, I've been an arbitrator for DART, the U.S. Postal Service, NASDAQ FINRA, Washington Metropolitan Airport Board, the Federal Mediation Conciliation Service. I've been in-house corporate counsel in the telecommunications, retail, and defense industries. I've been a municipal court judge for the city of Dallas and an administrative judge for the EEOC. I tell you all that so that you know that I have the depth and breadth of experience to start tackling those issues at the Texas Supreme Court. Moreover, I'm a graduate of the Hockaday School, Smith College with a degree in economics, and Georgetown University Law Center. I just want to take a moment for you to explain why does it matter in the Texas Supreme Court. I know you all are all excited about the presidential race, but guess what? What happens in the Supreme Court matters. In June, the U.S. Supreme Court said that they would no longer hear any cases regarding redistricting or gerrymandering. They're kicking it back to the states. So eventually, after the census, after the legislature redraws their maps, it's going to go through the courts, and it will be at the Texas Supreme Court. And if you look at the makeup of the Texas Supreme Court, and if we don't change it, we're in trouble. Right now, the Texas Supreme Court there are 9 justices. All 9 of them are from the other party. There's no one that looks like a majority of this audience on the Texas Supreme Court. And in the 174-year history of the Supreme Court, there's never been an African-American female. It is time that our voices be heard. It is time that you have someone. Thank you.
Very good. Thank you so much, Judge Williams. So now we're going to open up the floor for questions from the audience. Yes, sir.
What is your feeling about moving judges from being elected to being appointed?
Well, I think we in Texas are very fortunate to be able to elect our judges. If I had to be appointed, I probably wouldn't get appointed because it's the good old boy system all over again. Now, the only time it came to be a problem was 2014, Dallas County elected 14 black judges, and then when they elected those 19 black female judges last year in Harris County, they said enough is enough. But the funny thing, when Justice Hex said that we need to have this committee, he didn't worry about it when I hope my Republican opponent got a part of the Texas Supreme Court, had never been a judge in his life. He was Rick Perry's chief of staff. There was an opening. Rick Perry said, hey, you want to be on the Texas Supreme Court? Pretty good hookup, right? But you get good old boys in the Texas Supreme Court, you get good old boys in, and it's time that we change that. So I believe in the elected system because then the total people get a chance to vote. It's not the exclusive Dallas Bar Association or Texas State Bar or anyone else. The actual citizens of Texas get to vote, and that's what the Texas Supreme Court needs to be about.
All right. Thank you. Yes, sir.
Yes. What's your opinion on the death penalty in Texas, leading the nation at that?
Well, actually, this raises an interesting point. The Texas Supreme Court, unlike the United States Supreme Court, does not hear any criminal cases whatsoever. We have the Court of Criminal Appeals, which I think you're going to be hearing from those candidates later
Yes.
today.
Yes.
They are the court of last result. Oh, I can't talk anymore. Result for criminal issues. And also, I warn you, if it's a sitting judge, we can't give an opinion on a topic because that issue might become before us, and we're bound by the Texas Code of Judicial Conduct not to give any indication how we may or may not rule.
Okay, very good. Thank you. Yes, sir.
What do you think your impact will be? You elected to the Texas Supreme Court. There are 9 in a different party, and then now you sit on the Supreme Court. What will your impact be?
Well, actually, to keep hope alive, there are 4 Democrats running, and hopefully if all 4 of us win, we won't be a majority, but we'll have strong dissenting opinions, and it's getting that voice heard. Right now, our voices have not been heard, but I believe that we can work across the aisle because we are all lawyers, we're all judges, and we want to do what's best for the citizens of Texas. And the issue has been, they've been one party, they have one idea. They need someone there to push the issue, to push the different ideas up for the decision. So I think it's going to be great, and we're going to make some decisions. Now, there will be probably some issues where it will split down party lines, and I expect that. But I think that we will be able to work cohesively.
I want you to keep the mic, but I want you to move it closer to your mouth. Yes, ma'am.
The Texas Supreme Court does end up ruling in a lot of the education funding cases, and we know, schools are seeing a huge issue with that because the states push back on, and then they blame it on the that they're raising your sales tax, your property taxes there. So where do you see that you can make a difference in the way funding is distributed?
Okay, well, the distribution of funds is a legislative function, not a judicial function. Now, after the legislature has allocated funds, if there is a lawsuit, I can't tell you. All I can tell you is you have someone who's had to work hard every day in her life. Nothing's ever been given to me. I understand what it's like to be a working class person in this state. I recognize the value of public education. And that's all I can say.
All right. Yeah, I have a question over here. Yes, ma'am.
There's can you educate us if the Texas Supreme Court or the other higher courts the justices come from certain parts of the state?
Well, it doesn't matter. There are 9 seats on the part of the Texas Supreme Court, and we're from all over the state. It's not allocated like this is the Dallas seat, this is the Houston seat. We're elected statewide, so anyone who votes for me, if you've got relatives in Longview, Marshall, Tyler, Abilene, Midland, Odessa, Wichita Falls, Harlingen, McAllen, you can vote for me. So there's no designated area like a legislator.
Okay, so it's statewide.
Statewide.
Okay. Yes, ma'am.
So the Texas Supreme Court is completely Republican and has been a really long time. When you read the Court of Appeals statutes, the rules, right? It says that it's discretionary but if there is clear error in the lower courts, they're supposed to correct it. What is your position on when the Supreme Court they just deny cases and don't hear a lot, and knowing that even if you appeal to SCOTUS only hears 1% of those cases. So what would your position be on issuing, on ruling on cases like that, where the Court of Appeals has denied or has issued opinions that may differ with statute? How likely are you to deny? And if you would not deny, how are you going to deal with a court that is predominantly a completely different party?
Okay, this question, for those of you who don't know, just because you appeal a case to the Texas Supreme Court, it might not get all the way up to actual hearing before the Texas Supreme Court. And the first level is a level of review where primarily the law clerks will look through and say, hey, judge or justice, this is an interesting an interesting case that is percolated up through the Court of Appeals, or this is an issue that's percolating through the states. I think the one way how you get more cases is that you have a diverse viewpoint. So someone who's been with the Texas Supreme Court for 25 years or comes from that Republican mindset, they're going to maybe want to deny the court hearing certain cases, as opposed to someone like me who's been a trial court judge who happens to have a real working class background. I might say, you know, guys, we really need to take a look at this case. So I can't tell you specifically how I'm going to, but I will be reading every document, every piece of paper that comes up. And if I see an issue that needs, that I believe that the court needs to hear, I'm going to vote for it. But again, I'm just one of nine.
Thank you. Any other questions from the audience? I do want to bring up one to kind of piggyback off of that. So let's say because of your experience in the district court and you're there and something does percolate up and the others don't necessarily want to hear it, how would you really push to get something that's meaningful for all the people, that impacts everyday working people's lives, to have that case actually get before all of you all?
I think it's persuasion. Also, I plan on hiring the best, brightest law clerks possible. And I think a lot of times the law clerks talk a lot. So we're going to have our marching orders on certain issues and certain theories. That's all you can do. You're one of nine. But I'm very convinced that they just need to hear that dissenting opinion. They're not hearing anything right now. They're lock, stock, and barrel, one viewpoint. And they're going to start hearing other viewpoints. And like I said before, people truly want to do what's best for Texas, but a lot of times they just don't know it.
Okay, all right. Oh, this is not a quiet crowd. Yes, sir.
Right here, there are a lot of people sitting in jails, locked up simply because they can't afford the bail out. How do you feel about bail reform or any cash bail?
Well, since I'm a civil district court judge and the Texas Supreme Court only handles civil issues, that's probably not an issue that's going to come up before me. And I can't say that I've been in a position to actually understand the issues that are raised in it. I understand that in Dallas and Houston, they are reviewing the bail issues, but that's primarily a responsibility of the criminal courts and eventually up to the Court of Criminal Appeals. So we handle no bail issues in the civil courts.
Okay, gentlemen. You. Yes.
Yeah, I was curious as to how long is your term, and are there term limits?
Okay, for the Texas Supreme Court, it's 6 years. No, there are no term limits. So Justice Heck, who is our Chief Justice, has been on the Texas Supreme Court for 30 years. It's time for change.
Yes.
It's time for change, but we need to make sure that those that we put in are experienced and qualified. And in my race, my opponent has never been a judge in her life, and she wants the Texas Supreme Court to be the on-the-job training for her. And I just think we've got too many important issues. We need folks who have experience, who've actually put on the black robe, who've actually had to make hard decisions, and who've actually probably been massacred in the press for their decisions.
Okay. So what is your general judicial philosophy then, since you have that experience?
Follow the law, listen carefully, and make sure that decision is right for the citizens of Texas.
To the floor. Yes, ma'am, and I'll come to you.
So with the cost of litigation, there is a growing population in the civil court of pro se representation. And that is generally not liked by judges for reason. But what would be your approach to help address that issue, and or how do you see the whole pro se representation issue?
I think you raise a very interesting point. As a member of the Texas Supreme Court, we're each assigned other statutory duties, and one is the Access to Justice Fund. And I know just at the district court level, we do have, there's a growing population of individuals who represent themselves. The difficulty is that as you go up the steps of trial courts in the state of Texas, it becomes more and more difficult for you to represent yourself. For example, if you go before a justice of the peace, you can pretty much represent yourself. But as a district court judge, I've got to hold the pro se person to the same standards as I do an attorney, which means compliance with the Texas Rules of Evidence, Texas Rules of Civil Procedure, and any other applicable statute. So it is reaching a crisis stage, but I don't know if we're at the position where we'll start assigning or having a roster like the criminal courts have for those who can't afford it. I know as a district court judge, we hand out, if we see a pro se person, we hand out legal resources so that folks can get education.
All right, thank you. Yes, sir.
Yes, the Texas policy or code on child support, I think, is just jacked up. It should be thrown out and all started over again. And I'm not speaking just because I'm one of the victims. But I know personally of a mother that went to file for child support that has 3 DWIs and a felony, and the father has a clean record. And when he got ready to fight, he just couldn't. It's like they automatically think the mother is the best candidate for the child. Should there be a process in place, and if somebody presented that, that's something that could go all the way up to the Texas Supreme Court?
Well, I think you're talking about more statutory reasons for child support, and you need to deal with your legislature, which is why I'm emphasizing again, you need to vote up and down the ballot. So we need folks in the Texas State Legislature, in the House, and in the Senate to propose legislation to change it. And then if there are any challenges, then that goes through the court system. But it has to start at the legislative stage.
Okay. Yes, ma'am.
Hi, you mentioned that it's been 30 years and it's time for change. What are some key issues related to the time that you have that you will tackle? Because I'm very interested in issues concerning black women, and black women being the lowest on the totem pole. Will you get any cases related to that, and what are some issues that you...
The only cases I get are those that are filed. So if you're looking for advocacy, again, you're going to look at your legislators, someone in the House or Senate. So for example, the death rate for black women having babies is like 3 or 4 times the rate for white women. That needs to be taken care of at the legislature. Something needs to be taken care of. Then once the legislation is passed, then if there are any challenges, it goes up to the courts. But so judges and justices are not advocates.
Okay. Any other questions? No, well, I will take a stab here. So, what is your understanding of the distinctions between the provisions of the U.S. and Texas constitutions in regards to civil cases?
Okay, we could spend here all night. That's such as like asking, did God create the world? You're gonna have to narrowly ask that question.
And narrow it down.
Yeah.
I don't know.
I don't know what the person's asking. I really don't.
Narrow it down.
Okay, well then ask me another question.
Alrighty. So, do you believe the composition of juries adequately and fairly reflects society at large? And we know that you do your class.
Yeah, I did a Citizen Civil Academy, but I think that's going to the selection of jurors in civil cases. I make sure, and it's one of my goals to make sure that my jury panel reflects Dallas County. I'm one of the few civil judges in Dallas County who will allow a Batson challenge. A Batson challenge is more frequently seen in the criminal courts, where after both parties have exercised their peremptory strikes, you look at who are the top 12. And so sometimes we see that African Americans and Hispanics have been unfairly stricken from the record. So if an attorney is on their P's and Q's, they will ask for a Batson challenge. We've had several successful Batson challenges in my court where we've had to put back on a black or Hispanic person who was illegally struck off the jury panel. And so you need to ensure that, I don't understand why some of my colleagues won't do it. So it's important to be aggressive and assertive, and don't give...
Thank you. Sorry. Yes, sir.
Does the Texas Supreme Court handle the redistricting?
That's what I just said. Yes, it now will.
It will now.
It will.
So what would, share again what your thoughts on in regards to the redistricting?
I can't.
Not yet?
I can't.
All right.
That's indicating an opinion on how I might rule. So I can't. All I can do is identify that's an issue that's coming up, and if it's dear and near to your heart, look at the composition of the Texas Supreme Court and say to yourself, do I feel comfortable with those 9 individuals sitting there now to make a decision regarding redistricting? If not, then you need to look at the candidates, including me.
Okay. Good question.
So can you explain the difference between the way Texas has its constitutional amendments, which we will be voting for on our ballots, and the way that we just have our regular state laws? How does that differ in the courts, or does it not?
I'm not quite sure you say how it
So-
differs in the court. It would only come up in the court if there's a challenge
Right, so
to it.
So if I challenge a regular law as opposed to challenge like the 2106, which was the penal code, so in your court, it doesn't matter. Is it harder to get a ruling on a change to the Constitution or a change to just the regular law?
Well, eventually, if there is a change to the Texas Constitution, it has to be voted on by the people. It's easier to invalidate a law through a legal challenge.
Okay. All right, so I will take this opportunity to ask you a question on, because I feel like this is a great education opportunity. Really nitty gritty in 1 minute, if you can, that's 350 words. Supreme Court, really, what is the boundaries, the role, the purpose of the Supreme Court?
Okay, so Texas Supreme
Texas
Court,
Supreme
very
Supreme
good.
Court, thank
Someone's
you.
listening, all
Yes.
right. So in Texas, we have a separate Supreme Court for civil issues, and by civil, juvenile, family, probate, and what I primarily do, lots of commercial cases, oil and gas, real estate, personal injury, medical malpractice. And then on the other side, we have the Court of Criminal Appeals, which is the highest court for criminal cases. So as I think someone noted on the right-hand side, just because you appeal a case to the Texas Supreme Court doesn't mean it's going to get eventually heard. There's several steps of review before they even decide to hear the case. What else do you want? There are 9 justices. Usually the terms are 6 years staggered, but there are 4 vacancies this year because one of the justices got appointed to the federal court. So we have an opportunity to flip 4 seats. In each of the Supreme Court races, there are contested races. So you do have a choice. And this is the first time.
Thank you. Yes, sir.
How many cases does the Supreme Court have every year?
Well, it depends on the volume. Right now, I can give Justice Heck, who is the Chief Justice for the Texas Supreme Court, kudos because he clears it out. They have approximately 60 to 140 cases within the last year, and they've gotten decisions out by May, which is absolutely amazing because these aren't just 5-page decisions. These are 20, 30 pages where it's going to impact the entire state of Texas. So it takes a lot of time, a lot of analysis to make sure that it's right. But they've done a good job on reducing the backlog and staying on target.
Okay, so another question. With that, you say analysis of the cases. So no one is coming and presenting and arguing their side for the cases. You guys would then review the transcripts and everything that was already presented during a trial as a justice on the Texas Supreme Court?
Well, you're halfway there.
Okay.
So at a trial court, that's where we take evidence. We have witnesses and testimony. Then if you're not satisfied with the decision, you can appeal to the Court of Appeals. At the Court of Appeals, it's not a new trial. You don't present new witnesses or evidence. Those Court of Appeals justices will look at the record, the transcript, and make a decision whether or not an error has occurred in the application of law.
Okay.
All right, so then when you go to the Texas Supreme Court, instead of looking at the parties, they're going to look at the Court of Appeals and see if the Court of Appeals followed the law correctly.
Okay, so now does it start to make sense?
Yes, yes.
Okay, yes, because this is a definitely different layer than I think what people are accustomed to. So
Good point.
litigants are not ever coming before you guys?
At the Texas Supreme Court, no.
Okay, all right.
Just,
You hear cases on landmarks where the eminent domain is being taken for the border wall. You hear cases about whether a community can continue to ban fracking, those
Correct.
kinds of things.
correct. So it's very important that you have experienced individuals on the Texas Supreme Court.
Okay. Any other questions? No? Okay. Well, Judge Williams, you can close out for 2 minutes.
All right, first of all, I'd like to thank the Dallas Examiner and Molly Belt for continuing to put on Monday Night Politics. I first appeared on Monday Night Politics in 2014 and then appeared again in 2018. And this is the only forum like this in Dallas where folks can come in, ask questions, and actually learn about the races and the candidates. So thank you very much. And the Supreme Court, for the first time in Texas in a long time, we have contested races in the Democratic Party. There's not only a crisis at the national stage, there's a crisis throughout this whole country. And I'm urging you to please vote from the bottom up. Every position is so important because if you just make a change at the top, you're not going to have change at the bottom. And particularly in our courts, we're going to be facing a lot of important issues. I think the Supreme Court has started. They started with gerrymandering and redistricting. They're going to start passing more and more important issues to the states, which makes it so important that we have the right people on the Texas Supreme Court. And experience matters. And I'm so proud of the endorsements that I've gotten. My endorsements represent the state of Texas, so many different viewpoints. Let me refer you to my website, www.judgestaci.com. That's Staci with an I. Take a look at our Facebook page, Judge Staci Williams for Texas Supreme Court. Please be educated and realize experience matters, education matters. We need folks who understand what it's like to be a working class person in this town and to actually have to work for a job.
Keep the mic at your mouth.
Thank you.
You done? All right. Okay, so now we're going to take another moment here as we get ready for the next group to come on. So if I could have the candidates for the Court of Criminal Appeals, Place 3, that would be Dan Woods, Elizabeth Frizell, and William DeMond. And while we're waiting for everyone to join the stage here, we will give another moment of gratitude here for our sponsors for making Monday Night Politics possible. So we would like to give thanks to the Dallas Association of Realtors, Dallas Panhellenic Council, Theta Alpha Chapter of Omega Psi Phi, Iota Phi Theta Fraternity Incorporated, Omicron Mu Omega Chapter Alpha Kappa Alpha Sorority, and the Black Chamber of Commerce. So, last call for candidates. All right. I'm going to ask that you keep the mic. You have 2 minutes for your introduction, and you will have 1 minute for questions. Okay.
Well, thank you all for hosting this forum. This is actually a very great opportunity for us as candidates to get our message out to a lot of voters. And I'm running for a statewide office this time, so I have to cover the entire state of Texas. And I know you all know I can't cover the entire state, not by myself, but I'm hoping I have you, the people that aren't here that are listening to us through social media, to tell other people about us. I'm Judge Elizabeth Davis Frizell, and I am running for Texas Court of Criminal Appeals, Place 3. I thought Judge Williams gave an excellent overview of how the criminal court works. We have bifurcated trials where there's the civil side and there's the criminal side. I've been a criminal district court judge, and when we have trials, if someone doesn't like the outcome, they can appeal it to the Court of Appeals. If they don't like the outcome there, they can appeal it again to the Texas Court of Criminal Appeals. So I'm running for the highest criminal court in the state of Texas. We hear all the death penalty cases. Death penalty cases are direct appeal to the Texas Court of Criminal Appeals. We also hear other cases throughout the state, and I would be able to make sure that I'm reviewing the trials from judges across the state of Texas. I know in Dallas we have become a lot more progressive than we were when I first started practicing law. I've been doing criminal law for 26 years. But there are a lot of smaller towns that haven't caught up to the time yet. And it would be a pleasure for me to be able to review the papers and say, yes, Judge, you did a great job. Or no, you're going to have to do that again. We're going to reverse or remand. And I can do that as a Texas criminal court judge. I want to catch it before we have someone that serves 16 years in the penitentiary for something they didn't do. Before they serve 22 years or 32 years, because here in Dallas, we're number one, not in Texas, but in the country in wrongful convictions. Why do we wait until someone has served that time? Well, many times the Texas Court of Criminal Appeals takes a pass. And they don't even listen to the case. Do you know they have the discretion and authority to do that? Well, maybe we can make some changes if we get some new people on the Texas Court of Criminal Appeals. I've been a judge on every level except for the appellate level. I'm experienced and ready to go to the highest level, and I'm asking you to send me to the highest criminal court.
All right, thank you. So, yes, sir.
I don't know if you can answer this question or not, but recently in the last election, we had I guess it was a constitutional amendment to allow judges to sit on multiple benches and so, as you spoke, in small rural towns, so they could pass cases either quickly or with I guess I'm thinking it's more of a bias since you're just been bouncing your bias around. How do you feel about judges serving in multiple municipalities?
Well, the way the law is set up now, in some counties they do that. And matter of fact, I just had a case in Titus, Texas, and there was a judge there where some of the counties are very, very small. It's not like Dallas County. If there may be several different counties that are close and they'll go and serve in different counties. Here, I'm going to tell you the positives and negatives of that. The negatives are if you have one judge in each county, sometimes the judge may come in once a month. I had that happen, and my client's case was reset until the judge was in that county at that particular time. I think that's a negative to having judges serve in multiple counties. The positive is sometimes if you don't do that, you may not have a judge to serve in that particular county. So when I was a municipal court judge, and this was maybe 20 years ago, I was able to serve as a municipal court judge and actually practice law. I practiced for 13 years before I ran for judge. I couldn't practice in the court that I served in, but I was able to do both. But I never actually served in several different areas. I took it one at a time. I started as a judge for the city of Dallas, and then when I finished there, I served for the city of Box Springs. But later, okay, my time is up.
She was on a roll there. Okay.
Talk to me afterwards, and I'll finish that.
Any questions from the audience? Yes, sir.
You had mentioned the death penalty, that you all would hear death penalty cases. What would determine if you would hear a death penalty case?
Well, we would hear all the death penalty cases. The death penalty cases, when I say direct appeal, that means generally when you appeal a case, you had your trial, you didn't like the outcome, you appeal it to the Court of Appeals. On death penalty cases, you skip the Court of Appeals and you go directly to the Court of Criminal Appeals. So all of those come directly to us, and we would hear all of them. It's an automatic appeal. They don't just say, fortunately, we do get that. They don't just say death, and then you don't get to appeal. So it would come to us. We'd hear all of them. And I know you all have heard about a lot of cases on the news that are death penalty cases. I've been following them publicly, as well as many others, Ben Spencer, and many others that have been in the news. It is important who serves on these highest courts for the Court of Criminal Appeals. Right now, everyone on this court, and it's 9 judges, are Republicans. Most of them do not have any defense attorney background. It's important because as a defense attorney, before I became a judge, I get to see that there are people that are behind that case. It's not just an appellate brief that you read. There's a family you're affecting. Anytime it's reset, they're anxiously waiting the ruling and then it's reset. And then they're anxiously awaiting and then it's reset. You understand how much it affects families.
Thank you. I do want to remind everyone, no video recording of the forum. Okay, all right. Questions?
Right.
Yes, ma'am.
Are there any African Americans, people of color? There appears to be one, I think. Is there one on?
Well, there will be one when I get there. No, that's an excellent question. There are 0. And more than 50% of the cases that I hear are African American males that are defendants. But there are no African Americans, males or female, on this court. There are no Democrats. I think we need to change that. Most of the time that I've been serving on the court, I'm adding up my time as a lawyer and my time as a judge. The majority of the defendants are African American and Hispanic. Why is it that we can only be in front of the bench and we can't be on the bench, behind the bench, making the decision? Well, the answer is we can if you all go to the polls and you can start voting tomorrow. February 18th. Early voting starts. Let's go all the way. I started at the lowest court, the municipal court, and I'm asking you to take me to the highest court. I'm ready. I'm experienced. I came in #1 in the bar poll for all the people. I have 2 Democratic opponents. For all the people in this race, I came in #1. And you know who votes in that? All lawyers across the entire state of Texas are saying I'm ready. And I'm the best candidate who's qualified for this particular race. I agree, and I hope you all do too.
Thank you. All right. All right. Questions from the audience? Yes, ma'am.
Due to the fact that death penalties are handled differently, and the fact that Texas has had so many innocent people that have been sentenced. Now, don't get me wrong, I was definitely a strong component for death penalty, but I have since all these innocent people are being sent changed. If you are sent to death penalty, you automatically get a writ. Is that right? Because it actually goes up the level. It's not like any other case. It has to be seen. And there's been cases where the attorneys were asleep. Now, if you see something like this in a case, that and the other factors, how would you handle that differently?
That is an excellent question. You don't get an automatic writ, but you can file a writ. And many writs are filed. Writ is just a post-appeal way of saying, hey, something happened wrong in this trial. I know my appeal time is up, or whatever my time limit is, but I can still file a writ, or you're asking the judge for an order to overturn it. On the Texas Court of Criminal Appeals, we have the power to say, no, you didn't get this right. You know what they said on that case where the lawyer was sleeping? They said, well, it didn't happen in a critical stage of the trial. So we're not going to send it back. Well, what is a critical stage of the trial? If my life is on the line, my family, every stage is a critical stage of the trial. You shouldn't be sleeping through any of it. I can't tell you how I vote on a case in advance, but I do know this, that if someone is sleeping as a Texas Criminal Court of Appeals judge, I have the power to remand that and say, you're going to do this trial again. And can we have a fair trial this time? I have the power to do that under the right facts and circumstances, and I would do that under the right facts and circumstances. That is a part of what we should be doing. Sometimes the judges on this court, they don't even hear the case, and they have the discretion to do that. That's not fairness, and that's not justice. You're sending us there to hear the case and to render a decision.
Right. Thank you. Okay, so I do have a question about that. So someone is asleep, you guys read through it, and you see that maybe things weren't done as they should have been for a defendant. How do you specifically say that, yes, this should be retried versus just kind of letting it go away?
We say it should be retried. We have the power to issue an opinion that says, try the case again. I'm sending you back to the trial court. I've been a trial court judge. I can say, look, trial court judge, hear this case again. We're going to do this again. I can remand and say I need new evidence on cases as well. We can do what's called request a bill as an attorney. We can say, look, judge, you have the discretion to keep this evidence out that I'm trying to get to the jury. Mitigating evidence that would help it be a lesser sentence. Something about mental health, drug addictions, whatever it is I'm trying to get in, I can ask for a bill. And all that means is, judge, let me just read into the record what I would have said and what this jury would have heard if you had let me. So that when I appeal it, the Court of Appeals and the Texas Court of Criminal Appeals can see what I was trying to get into. So we can remand it and say we want more evidence, or we can say new trial. We're able to do that. We can do that. And fortunately, I'm not alone. There are three of us total. There are 2 other district judges that are running also. We're not running against each other. There are 9 on the court. If each of us win, that's 3 votes out of 9. We can change it right here in this room.
Thank you. Okay, back to the floor. Ms. Torres, I'll come to you. You had a question?
So, looking back over the last year or so, because you can't make a comment on future cases, but if you look on a back case, is there a case that just really stood out to you that you would have handled differently had you been on the court at that time?
Oh, there are so many. How much time do I have?
Only a minute.
Okay, yeah, there are so many, but here's what the rule is. is we can't comment in a way that would give the public an indication how we would rule on another case. So say, for example, if I say, here's what I would have done there, well, I may have a very similar case that comes in front of me. And then they say, well, we know what Judge Frizell is going to do because in Monday Night Politics, she told us. So I have to be careful as far as specific facts. But in general, one of them was already brought up as far as sleeping. But I know some of you may have heard of a case where someone had a death penalty case and they were filing a writ and they were 15 minutes late. And the Chief Justice, Sharon Keller, said, no, you're late. Too bad. We're going to put him to death. Well, there are lives that we're dealing with, and because I'm not only a mother, I'm a wife, I'm a lawyer, I'm a judge, I understand that there are families that are relying on me as a Texas Court of Criminal Appeals judge in my decision. 15 minutes, there are rules and they should be followed, but there are families. Do you put someone to death because their lawyer, which they had no control over, was 15 minutes late in filing some paperwork? I think there should be some compassion and there should be some grace.
Thank you. Okay. Yes, sir.
When you were speaking earlier, you were talking about you wanted to send a case back to a lower court. Is that you individually, or is that you, in your opinion, now you have to bring on the others where there's a majority opinion? Could it be just one judge making that decision, or is it a majority opinion that makes that decision to send it back?
That is an excellent question. On the Texas Court of Criminal Appeals, you have cases that are heard en banc. En banc just means the entire court, all 9 judges. You also have cases that are heard per curiam. Per curiam means 3 judges. Many of the cases, it is just 3 judges, and they are basically speaking for the entire court. Now, let's say I have 3 judges that issue a ruling, and I'm thinking, why did they say that decision spoke for me? Because it didn't. As a judge, I have the right to write a dissenting opinion, and I believe all dissenting opinions should be published. Let me tell you why. When there's a dissenting opinion, as a lawyer, I can include a dissenting opinion in my brief, just like I can include the decision that actually made the rule of law, the case law. I can include either one. It's up to the court if the dissenting opinion is published. I think it's important to publish it because as a lawyer, I have quoted dissenting opinions quite often. But you're right, it's not always the entire court. Sometimes it's 3 judges speaking for the entire court. It's important that you're able to work well with others and also have a different perspective. See, sometimes your background, you can say, wait a minute, have you thought about the other side?
Thank you.
All right, my time is up.
Yes. Okay. Any other? Yes, sir.
Judge Williams mentioned staff. How large is the staff for you? So the people who will be working with you, reading the stuff, because a lot of it comes to you because someone else read it and brought it to your attention. You may not have heard it yourself first. So the different legal strategies or what was meant, the clerks, the people.
Let me make sure I understand your question. You said sometimes it's brought to me.
Yeah, if you haven't read all the court materials, maybe 50,000 pages, and you assign different sections to different people, how large of a staff are you appointed or?
Oh, that's a good question. I understand what you're saying. We do have briefing attorneys. There's one briefing attorney that generally is very consistent. That person is probably there for years. They know how the court works, the time limits. Generally, there's another briefing attorney that's there maybe a year at a time, sometimes 2. Here recently, some of them have stayed there for 2 years. In the past, it's only been 1 year. Some of them are straight out of law school. They're ready to do the research, and they're there. We have briefing attorneys. We have staffing attorneys. So we do have resources we can go to as judges. And I always remind people, we have those resources as judges, and we have time to render our decision. When you're a trial court judge, you're calling balls and strikes immediately. Objection sustained, overruled, whether this evidence comes in or not, and we're grading their papers. So it helps to have been in that position to make those decisions as a trial court judge, but on the Texas Court of Criminal Appeals, you'd have a little more time and a little more resources to make sure that the lower courts got it right.
Okay. Any other questions? Yes, sir.
In today's world, I guess you could say in Dallas, we're in Texas, is what we're dealing with. The penalty for committing a crime varies based on if the judge had a midnight the night before or whatever. A good example is this. I think I can't remember the first name. It's Alexander, who got a 20-year sentence for shooting a warning shot, versus Amber Gagger, for example, got a 10-year sentence for killing a man, an innocent person. Could the Court of Appeal really look at something? It wasn't no bad trial, did nothing go wrong, so you don't have nothing to make them retrial, but just the penalty phase. If a person want to appeal that, how will the Court of Appeal handle it, or will they even consider looking at it?
The law says that the Texas Court of Criminal Appeals should view the case in the light most favorable to the trier of fact. The trier of fact is the judge or jury. So we have to view it in the light of, we weren't there for the trial. Did they abuse their discretion? There's a lot of leeway as far as whether they abused their discretion, and many times the Texas Court of Criminal Appeals says, oh, they didn't abuse their discretion. Well, what's abuse? Is it abusive when you have a case like that where someone shoots away? This is what a lot of people don't realize. You can get the death penalty for being a party to a murder. Did you know that? Someone goes into a bank, they kill somebody, they swear to God they don't have any bullets in the gun, and you're like, okay, I need a little cash. Not a good decision, but they make it, and they go in the bank, and lo and behold, there were some bullets in the gun, someone gets killed. The other person's the lookout. They assisted, they're a party, they assisted the offense. Do you know both of them are eligible for the death penalty? Did you know that under the law of parties? So we have to look at that. Should that be life without the possibility of parole, possibly, instead of the death penalty? Well, that's something that we have to look at as judges.
Thank you. Okay. Yes, ma'am.
Oh, how are you doing? Judge Frizell, I am finding that the legal system has become so legalese, okay? Like when we did the no bond issue, it was supposed to be yes meant no and no meant yes. It's becoming so legalese. And it's beginning to where if the government mistreats you, you have to have a lawyer to even get in court, and that's not fair to the poor people. If you don't get a lawyer, you don't get an appeal to the appeals court. So my question is, what if, and this is maybe not necessarily, this is more like city of Dallas still, do you foresee any effort to try to get an appeal without, to review the case that a council member makes or a state representative makes if they come up with a law? Is there some kind of appeal that we could appeal before it goes to court? Do you have like a mediation or something like that? Maybe do you foresee that before you go to court, and that way they can kind of recognize?
That's a good question. Mediation. You see mediation on the civil side, you generally don't see it on the criminal side. And I'll tell you why. I'll give you an example. I was a domestic violence judge for 8 years. Sometimes there's an unlevel playing field when you bargain on criminal cases, because somebody could be a little stronger. And another person could say, well, I'll just go along with that. Mediation is about reaching an agreement. On a crime, we're not trying to reach an agreement. If somebody is wrong, there should be some appropriate punishment for that. And if someone else is just more forgiving, does that mean that person should not be appropriately punished? So you see mediation is more on the civil side. But let me tell you what my recommendation is. There are a lot of people who just cannot access the system because it's so expensive. Lawyers charge $400, $500, $600, $700 an hour. How do you get into the system? Here's what my solution is. I think we should have internships for lawyers just like they do in med school. After you graduate from med school, there's a 1-year internship. We can do that with law. So that year, that lawyer learns how to practice law, and they get either a sliding scale payment or free, and they help you for free. Sometimes lawyers straight out of school are very aggressive and will help you.
Thank you. Well, good. Okay. Any other questions?
I look forward to that.
Okay, I'll come here and then here.
I do want to continue on that line because a lot of us hear the Miranda rights, you have the right to remain silent, and this was started by, this campaign was started by one guy whose name was actually Miranda. So, but it's a misconception. Everybody is not entitled to an attorney. It's only in certain cases that you are allowed a court-appointed attorney. So, I think that was an excellent question that she asked, and also your response was, because when you said that, the first thing that came to my mind was legal clinics, but they have sliding fees, like the legal services in North Texas, and they don't service everybody.
That's right.
And everybody knows that, well, not everybody, but middle-class people know that what you said is true. And
A lot of that is because they don't have enough lawyers. So you have to wait 2 years. You go sign up, you have to wait 2 years to get a lawyer. But if you had these lawyers that are asking them, can I work for you, North Texas Legal Services? I have to complete my 1-year internship. I'm looking for somewhere to do some free work. We'd have more lawyers, and you wouldn't have to wait a year to get a free lawyer to get in there in court. They're ready to learn. I was very eager when I first got out of law school. I wanted to learn. It helps them, and it helps you. They have too many cases. They're overloaded. They want to help you, but when you go sign up, who wants to wait 2 years to get custody of their child? or to be represented in court. You've already had your court date. So that's a very good question. You get a lawyer when you are either you have a criminal case or you're subject to go to jail, for example, contempt on child support cases. I used to do family law. If you could be held in contempt and could go to jail, you have the right to have a court-appointed attorney. Other than that, you have that right if you have a criminal case pending against you, not necessarily civil or divorce or family. And also termination of rights. If they're going to terminate your rights for child protective service cases, terminate. Now custody, you got to hire your own lawyer. Termination of your parental rights, you also have the right to a court appointment.
Okay. Camille.
I didn't finish my question, she started talking.
Is there, but
I'll
just
come
to
back.
clarify kind of that same thing, but there is a court-appointed indigent attorney for appellate cases, so you can
Yes.
appeal your case with a court-appointed attorney.
That is correct.
That it is lengthy, and that could be part of speedy trial things that could take place, or making a rotating docket. If you practice criminal law, you have to be on the docket, but there's other solutions, but it is part of the right.
No, that's a good point. You do have the right to a court-appointed attorney for appellate purpose as well. That transcript alone is very expensive if you hire someone to do the appeal for you. If you hire someone and you don't have a court-appointed attorney for appellate purposes, it is your responsibility to pay for that transcript. It could be days and weeks of testimony, and just that is expensive. You have to have that to write your appellate brief to get the appeal in front of the Court of Appeals. So yes, she's right. You do have the right to a court-appointed attorney for purposes of appeal as well.
Okay.
On a criminal case.
Does
On a
that
criminal.
take care of everything?
I heard what you said, but at the same time, what would be some of the things, because I'm looking at the barriers that are currently in place, what would you do to help out middle class who are raising families, paying insurance, paying house notes? I can go on over the expense list. What would you do in order to further along with the students? How would you do that project?
You mean my recommendation about having a one-year internship? When you have a one-year internship, it's just like my son. He's a senior in high school. He has to do a certain amount of community service because he's on National Honor Society. So he knows I have to have 15 hours this semester, 15 hours next semester. So he looks for places that he can volunteer. He's on student council, so he has to have some more hours for that. Lawyers would do the same thing. If I graduated past the bar, I can't wait to start practicing law and getting the big bucks, so I got to get through this internship. I'll start calling people like North Texas Legal Services and say, do you have any cases I can do? Custody, child support, appeals, I'll do whatever because I have so many hours that I have to get in so I can get past this one-year internship and go make the big bucks. And you never know, maybe they won't do that. Maybe they'll do the 1 year and say, I want to stay here at North Texas Legal Services because I know I'm helping people and I'm learning. That would be my solution.
We don't have internships now. We don't have internships.
Not mandatory.
Okay.
If you want to do them. If you want to do them, but you can have a 1 year.
Stop. Y'all can't do that now. I know we get rowdy around here, but yes, ma'am.
So, 2 points. One is, how would that program be implemented in terms of the internship? And then 2, what would be your position on bail bond reform?
2 excellent questions. I'll try to condense it because I know my time is short. Number 1, it would have to be implemented through the State Bar of Texas. The State Bar of Texas, that same bar I told you I got number 1 in the bar poll, I think I'd have a little influence if I'm the Texas Court of Criminal Appeals judge. And I present it to them just like I'm presenting it here, saying, look, I've been practicing law for 26 years. Here's what we need to do. How can we make this happen? I'll have access to the people that set these programs up. I think they listen to me because they send me those little letters all the time saying, what can we do for equal access to justice? Can you give? It is important to give money, but we can also have some action. Second thing on bail bonds in 30 seconds. Here's what I recommend on bail bond. Bail bond reform. Bail bond should not cost money. It should not cost money. Yeah, y'all clap for that because that's a good point. Bail bond should be fact-based hearings like we do anything else. As judges, we have a prosecutor, we have a defense lawyer, they bring the evidence to us. We should do that as fact-based hearings. Don't say, okay, your crime was heinous. We're going to set it at $1 million. Your crime wasn't that bad, $500. Either you get out or you don't. Let me hear the facts. If I'm rich, I shouldn't get out on $1 million bond if I've killed someone and it's heinous.
Judge Frizell, thank you. All right. Any more questions? No. Okay.
Can the
legislature
make that happen?
Sandra
I
Crenshaw.
don't think they're gonna let me answer. I'll answer that after this is over.
I need you to raise your hand if you don't get to talk directly to the candidates.
Yes, ma'am.
Okay, now what is your question?
I just want to know, can the legislature assist with getting that, make it mandatory through the state bar?
Absolutely.
All
Sandra
right,
brought up
then,
a
let's
good
go
question.
with it.
Who knows who their state rep is?
That's
Ask them
right.
to propose a bill.
That's
We're running for office now. They're sending you all kind of flyers every day to your mailbox. Ask them who has proposed a bill for bail bond reform to do what Judge Frizell said and have fact-based hearings and not based on money. We can't just say reform it. Let's do it. We can propose legislation to do that. And if it comes to the courts, we'll hear that. We got plenty of judges to hear it as well. Talk to your legislators and ask them if they propose legislation to make fact-based hearings and not cash-based money bail bond. Ask them.
Okay, thank you. Any more questions? All right, you have 2 minutes for your closing.
All right. Well, thank you all for such a lively discussion. Y'all had such great questions. I don't even know if I need to close. I think I said everything I needed to say. But I know you all know that I recently ran for district attorney in 2018. And I got 49.999. I am going to assume that was a supporter that hoped that I won last time. But here's why I say that. A lot of times I have people say my vote doesn't matter. It's just one vote. What difference does it make? On election night, they told me I was 500 votes short. And there was a current investigation for 2,500 ballots. Your one vote makes a difference. If each person in this room just tells 10 people, do you know that can swing an election? This is one of the most important election years of our lives. Don't make this be the same thing as last time where you're sitting at home. Oh, somebody else will vote. It doesn't matter. Your voice matters. Your vote matters. Anytime you've complained about somebody needs to do something about that somebody is you. And you can work it through me. I'm here to be your instrument to be used on the Texas Court of Criminal Appeals. I will be your voice to say there are families. This isn't just a piece of paper, a brief that we're reading. There are families behind this. I have the experience, and I think I am uniquely qualified out of any of the candidates in this race because not only have I tried every type of case from theft to rape, robbery, murder, capital murder as a lawyer, I presided over almost every type of case as a judge. Rape, robbery, murder, arson, capital murder, I've heard death penalty writs. And I not only have the judicial and trial experience, I've done appellate briefs, I know the time limits, I know how to do citations, I'm a very good writer, researcher. We have the wealth of knowledge and experience right here. I have my friend Judge Tina U. Clinton that's running for Texas Court of Criminal Appeals Place 4 to serve right next to me. She's ready. We both started as municipal court judges together a long time ago. I have my friend Judge Staci Williams. We both started as municipal court judges a long time ago. We're not just running, saying, please vote for me, I'm black. Please vote for me, I'm female. Please vote for me, I'm qualified. I'm the most qualified person in this race. And I hope you will excel with Judge Elizabeth Frizell for Texas Court of Criminal Appeals Place 3.
All the way. That's right.
As you can hear, it is never a dull moment in Monday Night Politics. All right, so I will be calling the candidates for Court of Criminal Appeals, Place 4. So it's Judge Clinton and Stephen Mears. And while we're waiting for the candidates to come on stage, our final thank yous for the Greater Dallas League of Young Professionals, the North Texas Cluster of the Links Incorporated, KHVN, the Commission Radio Show, St. Luke, PSAM, and of course the African American Museum. So, you have 2 minutes for your opening and 1 minute for rowdy questions.
Thank you. My name is Tina Clinton, and I have the honor of serving you currently in Dallas County as your judge of Criminal District Court Number 1. We are in our 126th year in this criminal court. It is the oldest criminal court in the state of Texas, and it is my pleasure to be representing you. In 2020, I had the honor of running for the Texas Court of Criminal Appeals Place 4. I believe that my colleagues have already explained much about these courts, and I don't know how much more I can add. But I can tell you a little bit about why this race is so important and why 2020 is so pivotal. Let me explain to you just one of the cases that you may not be aware about. It is about a man by the name of Mr. Moore. He was sentenced to die. He was on death row when a Supreme Court case came down called Atkins that basically said that if you are intellectually disabled, you do not qualify for the death penalty. And he believed he was intellectually disabled. And so he petitioned through a writ up to the Court of Criminal Appeals, and he asked that his sentence be reduced from death penalty to something else. And so the Court of Criminal Appeals sent down to the trial court a mandate that said, please do a fact determination as to whether he is mentally disabled. The state, through the district attorney's office and the defense, agreed that he was mentally disabled. The court wrote an opinion saying that we do find he's mentally disabled and sent it up to the Court of Criminal Appeals. They disregarded that finding and they made their own findings saying that he is fine to be executed. It went up to the Supreme Court in 2017, and in 2017 the Supreme Court said, you're wrong, do it again. What did the Court of Criminal Appeals do? Same thing. And it had to go back up to the Supreme Court. In 2019, the Supreme Court told them yet again, you're wrong, do it again. You deserve better, ladies and gentlemen. 2020 is our chance.
All right. Okay, so, audience, here is your moment. Yes, ma'am? You have a question? I was talking to you in the hat. You raised your hand. Okay. Yes, sir.
So the makeup of, we know that Staci's court has no African-American females. Are there any Asian Americans, any non-whites on the court that you are currently on?
No. There are, just as Judge Frizell and Judge Williams spoke about, in both of the courts, you have 9 Republicans on each, men and women. Actually, there's more women on the Court of Criminal Appeals, but there are no people of color currently.
Yes, ma'am.
My question is this, that's no secret that bench has been Republican and Caucasian for a number of years. We haven't had Democratic leadership in Austin in a while, in various positions. What have you guys been doing to campaign to get the word? Because it is expensive to run a statewide race. What have you guys been doing to get the word out?
So I can at least say, because I've seen these ladies out, we have been running around the state of Texas. We have been crisscrossing. We meet on the roads in a certain locations, but we have been going not only to urban areas and suburban areas, but we have also been going to rural areas. Because I think in the last time when we saw in 2018 was that not only were we relatively close, we were about 4% away in some of these courts, but we also saw that the rural area came up a little bit because of the fact that Beto, when he ran for Congress, actually went to all 254 counties. And we saw them blip up just a little bit, but not enough. We turned suburban areas like Williamson County, that was the reddest county in the state of Texas, and we know that we can turn red counties blue. We need to work on Tarrant County because that's the last urban area that has not flipped, and they're pretty close. We need to turn Collin County, and we need to work the rural areas, not so that we win them, but we just get a percentage or two better.
Thank you. Okay. Any questions? Yes, sir.
Who are you endorsed by? Who are your top 3 endorsers?
So I've been endorsed by, so you want the whole list?
Your top 3.
Top 3. So organizationally, I can tell you that the Dallas Morning News, the San Antonio Express, the Austin Chronicle, and the Houston Chronicle has endorsed me. Statewide, Texas AFL-CIO, as well as Tejano Democrats. In terms of attorneys, I can tell you that the Association of Women Attorneys, the Black Bar from Austin, the Hispanic Bar from Austin, as well as 99% of all the endorsing Democratic clubs in the state of Texas.
All right. Yes, ma'am.
What are you very proud of accomplishing in your current role?
So in my current role, I have 2 things that I'm very proud of, and I'm going to talk about them as fast as I can, and hopefully maybe someone will ask another follow-up. The first is this. When it comes to bail reform, I've gone down to Austin in 2016 and asked for a more robust pretrial division so that we could have bail reform. They didn't listen to me until 2 months after I went to speak to the Senate Subcommittee on Criminal Justice. Harris County got sued. And then they tried passing the state legislative change, but they failed twice. When that lawsuit came to Dallas County and all of the judges were sued, I discovered, to my dismay, that when I got to Criminal District Court number 1, I was represented by Ken Paxton. I was the first judge to walk away from Ken Paxton. I've hired my own attorney who's a Democrat who believes in bail reform himself. And we have several judges that have now peeled off and have joined us in this endeavor. And I'm happy to lead that charge.
Yes, sir.
You can finish up what you got to say. That's my question.
There you go.
There's your follow-up.
That's my man. The other thing that I'm very proud of is that for 9 years I've been fighting with Dallas County in making sure that the judges have, in the criminal side, in the civil side they have it, but in the criminal side, an adult case management system that we can utilize. Technology matters. When you're holding someone in jail and we've got to get information from the jail to the judges, if you walk it over, it takes 1 to 2 days. Versus if you do it electronically, it could take, 2 seconds, right? But you know what we're using in the criminal courthouse? A mainframe system that was from the 1950s. And you know what? They spent $43 million trying to build something that we told them not to do. And now, for the last 4 weeks, I have been sitting in a room doing tech demos because Dallas County is finally going to purchase one. And I'm proud of that.
Wow.
10 years work.
Okay. Yes, ma'am.
I have a question about that. Will that centralize scheduling as well to make sure that then the witnesses and all those things that come into play that can delay trials?
So what it will do is make sure that notification goes out to all the attorneys and all the parties as well. It means that there will be more transparency because the public will have an access through the public portal to see what's going on. We'll have much more data, meaning we'll be able to know exactly what the length of a case is and which courts are slower than others. But there's also the question of how complex is a case. You expect a capital murder case to take longer than a possession case, right? And so that data will be available. And in addition to that, we will be able to look at the scheduling across the board of all the courts so that we can try to be much more efficient. And those are efficiency measures that the computer will be able to capture with data that we'll be able to use that right now with the mainframe we just don't have the ability to.
Okay. Yes, ma'am.
So, let's talk about government immunity and excessive force with law enforcement, whether that be police or, say, we have a lot going on at the border where we have women and kids being assaulted, sexually assaulted, and things like that. What do you see as something that the court can do to increase the level of accountability that occurs with abuses from those who are abusing their authority in law enforcement?
So the difficulty of being in a court, any court, whether it's an appellate court or a trial court, is the fact that we deal with the cases as they come to us. Unfortunately, the proactive actions come from the legislature. We deal with the back end, which is what the court system does. And in the highest appellate court in the state of Texas, that's even worse in the sense that we only take cases that are appealed to us. I can tell you that the current Court of Appeals only takes less than 10% of the cases that it's requested to review. About 30 death penalty cases a year. There is about 5,000 writs a year that are filed, and they handle much, much less than they could. And they handle way less than what they actually could. And so I would tell you that from the powers that I would have on this court, there would be a couple of priorities. Number one, increase the level of review across the board on discretionary reviews.
Thank you. Yes, sir. For her to continue?
Yes, you go.
Thank you. That's number one. Number two is leadership, because it doesn't require us to do a case level review, to go to the legislature and talk to them about where there are gaps in the law. For example, when I went as a sitting judge to go down to Austin to talk about pretrial division as well as money for bail reform and how cash bail needs to be reformed, that wasn't because I was trying to be a legislator, but because as a judge, I'm supposed to inform. And part of the people that I'm supposed to inform is the Texas legislature so that those gaps can be filled in on the law. How many times have you heard about any of the top justices going down to the legislature to even talk about any of those issues? It's been an absence in leadership that they could take, but that they don't.
Yes, sir.
So, if I'm not mistaken, this will be the first election Texas will have where we won't have straight tickets?
Yes, sir.
So, you just mentioned that veto was the flame that helped the lower ballot, but since we won't have that, are you in your mind thinking that those who will be the senator or whoever that nominee will be will help you guys and tell people to vote down ballot? Is there a plan to get people to vote down ballot?
So this is, I think, at least from my kind of point of view about how the politics hopefully will help us as Democrats. Y'all know that we need to flip 9 House seats to control the House,
Yes.
right? Now, 9 House seats. That means that Texas legislators across the board are working like crazy because not only do we need to flip 9, we need to keep everything that we've gained so far. That means a lot of money in ground game. Texas has also been declared a battleground state in terms of the presidential because if we win the presidential, and we have an option this time of possibly doing that, what do? We block the road to victory for any Republican. That means money is flowing into Texas, right? And if we work and coordinate together between those houses, those districts, and the judges who have an opportunity to give you true justice and fairness in Texas for the first time in 20 years plus, it's worthwhile for us to spend all of our time on the road and do everything that we can to win this for Texas.
Thank you. So I do have a question.
Yes, ma'am.
Rural versus urban. So we know urban, lots of crime, How has rural Texas responded to you guys with coming out to vote for change at the appellate level for criminal cases?
They're so excited. And let me tell you the reason why. They're so excited. Y'all need to come with us because it is so fun to go out there. They are so excited. They have not seen statewide candidates in so long. And not only that, these rural areas don't have the judges that you do. They don't talk about reform and efficiencies. They're still doing things the way that they've always done. And their chances of possibly getting a sitting judge in their local court that will take on all these issues is not in 2020. But you know what is? Top judges who make good law that force those lower judges to actually do what they need to do. So from their perspective, having these high courts turn and adding Democratic voices is their best chance of having some justice and fairness even in their local courts. And so they're excited, folks. They are so eager to have an opportunity to vote that y'all need to know that they are ready for this opportunity. We just need to do our part.
Yes, ma'am.
So, last election, I was really excited when the civil side, the Fifth Court of Appeals, flipped, right? It's 15 judges, 7 of them went Democrat, including the chief, which is the first time in over 30 years. And I was excited, and I was like, okay, we're gonna see some things happen at Fifth Court of Appeals. And I haven't seen it. I promise I haven't seen any change. I haven't seen any change in their rulings and their opinions. It's like everybody just assimilated into that culture. So, what are you going to do, you and your colleagues, to ensure that that does not happen at the criminal level and at the Supreme Court level, that you take the ground and don't assimilate? What are you going to do about that?
So I think that one of the best indicators for future action is past indicators. And so I told you, no one asked me to go down to the ledge to talk about these issues. I was even ahead of the lawsuits in what I saw was coming down the pipe. I can tell you that I have stood up against some of my own colleagues that are also Democrats when they wanted to use Ken Paxton. I said, you can, but I can't. I just can't. Because I can't trust him with the opinions that he's giving me. Because I don't think that he has bail reform as a priority. Because I don't think that he believes the same way I do. And so all the advice that he gives me, in my mind, is questionable. So I split up from them, and I took a Democratic lawyer who was excellent at federal court to help me maneuver with the plaintiffs a discussion. And it caused us to have a mediation that the Ken Paxton group didn't want to have. I'm willing to stand up, whether it means against even my own friends, when it means that it's the right thing to do. You can count on me to do that.
Thank you. Okay. Yes, ma'am.
Speaking of campaigns, there hasn't really been there hasn't been an effort for the party, the Democratic Party, to coordinate a true coordinated campaign, since Obama was in office. As a matter of fact, he did not work with the party because, well, you know. So, since we do know, and even with Neto, there wasn't a true coordinated campaign. The question is, do you foresee a true coordinated campaign being run through the Democratic Party for this very important 2020 election?
So TDP obviously has the option of how and what they want to coordinate. My understanding from the chair is that he understands that that is a lacking piece. And I can tell you that regardless of what he chooses to do, if he doesn't take leadership on that, I will call up every single one of the statewide judges who gets to the primary, and we will coordinate and we will start working forward. Because I can't wait for someone to actually do something that matters for Texans that is this important. And as much as I love my Democratic leadership, if they can't lead at a pivotal time, then those of us that have this many months already in, we are going to take the leadership that we need. So that means that if we need to start running the coordinated campaign, we sure heck will. You know what? These ladies and I, we're capable of it. We can organize, we can call people, we can make sure that the resources are there, and we're willing to do it. Ladies?
Yes.
Yes. Yes, ma'am. Yes, ma'am.
All righty. Any other questions? Yes, ma'am.
I didn't see any literature for you. Could you state clearly your name and the position for which you're running, please?
My name is Tina Clinton. Unfortunately, I'm the last Clinton left standing on the ballot, and I'm running for the Texas Court of Criminal Appeals, Place 4.
Thank you.
Thank you.
I have a question back here. Yes, ma'am.
We talked about earlier some issues in mental health, and you've been around the courthouse a long time, and you've had 2 aides that have gone to turn out to be impaired in their judgment, so to speak, or blocking. And would you be willing to, and since you can do it anonymously, you don't have to tell anybody, but will you promise that you will get those people before they get in such high positions and tell them that if they don't get rehab, that you will definitely turn them in? Can we get that commitment from you as a judge?
As a lawyer, a licensed lawyer, it is my duty to do so. I can tell you that, well, I didn't have that relationship with them. I think the hard part with mental health is always the fact that unless you have a diagnosis, unless you are privy to that diagnosis, sometimes people act in certain ways and it's not necessarily mental health. It's just sometimes judgment and it's other issues. But I can promise you that if...
Okay, we're gonna stop doing that.
But you do have my promise that if I am aware and if I know that it's not just a judgment issue, that I will uphold my oath to the bar and make sure that I do make sure that they get the help and that I do report so that even if they voluntarily don't want to get the help, it will be a mandatory road. Yes, ma'am.
Thank you. All right. Any questions? I do have a question.
Yes,
How
ma'am.
does this court and all of the other places, how did those decisions filter down to the lower courts and change how they rule and provide sentencing
Say that one more
in
time.
future cases. So how does the Criminal Court of Appeals, your opinions, and sending things back down to the lower courts, how does that affect change in those lower courts with their rulings and their sentencing structure?
So I can tell you about, for example, mental disability when it comes to the death penalty. So once it is determined by the Supreme Court of the United States that if you are mentally disabled, that you cannot be eligible for the death penalty. When the state seeks the death penalty cases, then what happens is that one of the charges that has to come forth from the court is if an issue of mental illness is raised, there has to be a fact finding that's done by the jury, whether that person is mentally disabled or not. So in cases that predate the Supreme Court case, what happens is exactly what happened in Mr. Moore's case. He writes a writ and he says, you know what, back then we didn't have that put before the jury. And so I'd like to say that I was mentally disabled back then at the time, and I still am now. And so then a fact finding has to occur. Normally now that we know what the law is, the jury would have to have that put before them by the attorneys, and they would have to make that decision.
Okay, alrighty. Yes, ma'am.
Just in line with that question that you're on, because one of my professors whose name is happened to be Dr. Butcher, he taught the death penalty. You cannot execute a person that is mentally unstable or what have you. But in the event that they take medication, and if they're back on their meds and they're competent at that point, they can be executed. Does the law still stand, or has it changed in that situation?
Oh my gosh, that's a great question. I'm sorry.
So there is a distinction between competency, which is what you're describing, and mental disability. So let me give you an example. Someone who is has an IQ under 70 is mentally disabled. Someone who is possibly schizophrenic may or may not be competent at any given time. And the issue of competency, whether they were competent at the time of the offense, may be raised by the defense. So competency, right, is an issue that is still an issue of mental health, but it is not a mental disability as defined by what the Supreme Court was talking about in the Atkins case, which is what I'm talking about.
Okay, so I do want to follow up on that, and I'm going to come to you. So since we have a high number of children being born with autism and Asperger's, and we know how that impairs their maturation and how they see the world and whatnot, does that fall in there? And second part, personality disorders, where you have your narcissist, you have your multiple personalities, your psychopaths, all of those kind of in that category. How do they fit into that, or do they not?
So that is a decision that many times is left to the jury,
Okay.
because what is basically stated is that people with intellectual disabilities cannot be executed under the Atkins case from the U.S. Supreme Court. And the rest of it becomes a fact-finding issue for the jurors.
Okay.
One of the things, there is a case that just came out like literally last week. It's the Brownlow case. And it's a Kaufman County case. And he was actually granted the writ that he was intellectually disabled. And in that case, one of the things that the Court of Criminal Appeals talks about is the fact that they're really struggling with what this really means and how they define, right, intellectual disabilities that fit under the Atkins case. And I think that's one of the things that the court, the structure of the court, needs to tackle, because it is a scientific
Run
issue.
out of time.
Oops.
Crenshaw, and then my man here.
Okay. I want to be sure I understand this, because if it is the way it sounds, I want to challenge it, okay? This because a person is mentally incompetent at the time of a crime, okay? And then they go somewhere else and get medication. Are y'all saying that
No, let me clarify that. So, there is, when Camille said about someone taking medication, like they're not eligible for anything, they can't go forward in court, and yet they take medication, and then they're normalized again, and then they go back before the court. So let me explain a little bit about competency. So competency can be that someone who is in jail or looking at a charge is not competent. And the question originally will be, are they competent now to stand trial? And the issue is whether they understand what is going on and can help their attorney with their own defense. And the answer may be they are not competent currently to go forward, and therefore we need to give them mental health treatment, or we need to send them to a hospital, etc., etc. Then the second question that is raised by attorneys generally is, were they then mentally competent at the time of the offense? And sometimes that becomes an issue, sometimes that does not become an issue.
Okay.
Let's use an example. The trial that the kid that was over in Fort Worth on the life support, as much as one judge said, yeah, take it, the hospital says no. He's in healthcare for 30 years. I'm really siding with the healthcare professionals. You're not really helping the child. How will the Court of Appeal handle that, though?
So are you talking about the one where the hospital wants to? Okay, that would be Judge Williams.
Yeah. That's not criminal.
High five, Staci. Tag team.
Judge Williams will follow up with you. Okay. Any more questions for criminal? Wait, we have one right here. Yes, ma'am.
Thank you for clarifying like the difference between the mental defects and mental health case. But there's still not, because the case on Kaufman that we're just talking about, he had a 62 IQ, but so there's not like just a scale that they say, well, this means not competent, right? They don't, and then that also though doesn't encompass the things you were describing earlier of if they have a spectrum disorder or something that may not be accounted for in an IQ.
So intellectual disability is one of the areas in criminal law that I think is a much more newcomer. That I think that the laws are evolving very strongly on the issues of mental disability, intellectual disability, IDs especially. And after that Supreme Court case came out, the way that we handle our cases, especially with death penalty or anything else, it has to be the fact decider who has to decide whether that truly is something that they believe or not. So the jury, if it's a jury, has to make a decision as to whether they believe whether the IQ is 100 or 62, whether that rises to what they call an intellectual disability. And you're going to have experts that testify about that. You're going to have doctors who are psychiatrists and experts that try to give you an understanding as a juror as to what that means. What is someone with an IQ of 62 capable of? And that is going to be what the jury uses.
Okay, Sandra.
Okay, what I'm trying to get clarification, if that person is mentally incompetent, okay, and then you give them some medication, you're not thinking that this person can go back and be held responsible for something that they committed when they were mentally incompetent.
Ms. Crenshaw, no, Ms. Crenshaw, what I'm saying is there are two times where competency is raised. One is competency to stand before any judge or any jury right now based upon your current status. You also have doctors who will also assess whether competency was an issue when the crime occurred. Those do not always equal the same thing. So it is a fact-finding issue for the defense and also for the court. Because just because someone is mentally incompetent now does not mean they were mentally incompetent then. Just because they were mentally incompetent then does not mean they're mentally incompetent now. And so that's why the doctors have to get involved. I pay a lot of money to doctors to do a meeting and to discover that given the background of the individual who is in question. And that is why I say that it is a very complicated matter, because you have to address now and then.
All right, so clear now? Yes, ma'am.
I think this has already been addressed, but I'll just for clarification. For someone who committed a crime at the age of 15 and 30 years is, or at a teenager at under the age of what, 16, I guess?
17.
17. They committed a crime. Are those crime sentences, are they now being expunged off of their records automatically, or do they have to have them expunged, or are they continuing to file them until life?
Juvenile records?
Yes.
Juvenile records, I have got to say. So I do everything that is adult criminal. And the only cases that the Court of Criminal Appeals would take are certified juveniles that actually come into the adult system. Everything that is in the juvenile system, Judge Williams, would you please raise your hand? Judge Williams.
All right, so I do have a question. Where does PTSD fall into all of this now?
PTSD is an issue that is now being addressed by the courts, by many courts that actually, primarily urban because of the resources, in the criminal court system through veterans courts.
Okay.
If you have a diagnosis of PTSD, then it's easy. If you don't have a diagnosis of PTSD, then if you are a veteran, the Veterans Court generally works with you to go to a doctor and get a diagnosis of yay or nay to admit you. So if you can get into a program, then what happens is that it is a diversion court in many other trial courts. A diversion court means that there is no adjudication of guilt. You go through the program, and if you finish the program, then there is no finding of guilt. There's no plea. It's actually dismissed and expunged. And Veterans Court actually has the lowest rate of recidivism of any of the specialty courts that we know of. And so they're very successful, and it's actually one of our best ways of being able to treat people.
All right, so, any other questions? Y'all have been great. Okay, you have 2 minutes to close.
So one of the issues that I want to talk to you about is this. I understand that there will be 3 of us in 2020. I hope that I can earn your vote so that I could be one of those 3 that represents you in the upcoming 2020 November election. One of the issues that we have in this highest court is not only that they are struggling with issues, and they are struggling badly because the Supreme Court has had to tell them twice on this issue, but they're also struggling because they refuse to write robust opinions. They sometimes even refuse to write opinions at all. They just deny a writ by saying it's denied, even on issues of junk science. That leaves us in a quandary as lower courts and as lawyers, because we don't know how to tell people what they can expect in the criminal court system. That's not justice, and that's not fairness. The highest court that has the ability to do what they do should give you a reason and a rationale for what they do. That's the way that fairness and justice and process actually works. What most Texans don't know is that that's lacking in the Court of Criminal Appeals. It has been lacking for a long time because they are not in danger of elections. 2020 is different, folks. 2020, we actually have an opportunity to demand better. We have an opportunity to demand a court that actually does its job, not only for all Texans, but for the criminal justice system overall. Because what happens at the top influences the bottom. We know that. We know that we can do great things here in Dallas County, and it can be overturned by those top courts. This is an opportunity for us to demand better, not only for ourselves, but for our families, our neighbors, and all Texans. And we don't have to wait for a president to do this. What do we have to do in order to do this? Vote. Come on, you can do better. How do we do this? Vote. Vote. Tina Clinton, thank you.
All right. Alrighty, everyone. So, thank you for your attendance and your great questions for the candidates. And again, tomorrow starts early voting. So, since she directed you guys to go out and vote online, go out and vote. Now, next week, we still have another forum. So, my House District 100 Candidates will be here, so I expect y'all to be very lively, so don't let me down. And we will also have the incumbent and the challenger for the Dallas County Democratic chair race here on Monday. All right, see, y'all are like, woo, okay, so until then, tell everyone to go vote. If you have questions, all of the candidate forms are online. You can share them with everyone. A lot of the candidates that are running in races have been on Coffee and Politics, so you can go and check them out and get some information on who this person is before you make your decision, so you can be the most informed voter when you pull that lever. All righty, good night.